Just turn your wrist down.
On April 17th, 2025, Boynton Beach police responded to Kohl's department store in Boynton Beach, Florida, after loss prevention flagged a Sephora department associate for systematic internal theft spanning multiple consecutive shifts. Samantha Spear, 18 years old and just 33 days into her employment, was charged with scheme to defraud, a third-degree felony under Florida law carrying a maximum of 5 years in prison, 5 years of probation, and a $5,000 fine. This is that encounter. What makes this encounter analytically significant is that 3 separate legal frameworks converge in a single room. A private employer confession that predates any police involvement, a Miranda waiver obtained at the precise moment custody attached, and a civil recovery instrument executed while criminal exposure was simultaneously building.
No, I don't. Huh? I don't know where the office is. Thanks. Oh, no problem.
How you doing, champ? Funny we see you again. This time we need you. Yeah. All right, so we're gonna go to the management office over there. That's where we have her.
Okay. So, what do we have so far?
So here's, I'm gonna just take a picture for my record keeping, and then I will give it to you. Her name is Samantha Spear. She's 18 years old. She works for Sephora. She's with us 33 days. We, through a tip and observation, were able to catch her stealing multiple items. And in the interview process, while they were interviewing her, she confessed to, stealing almost every day the last couple of weeks.
Okay.
She knows we work hard. Say again? She knows we work hard. She knows we work hard? Oh, well, no. Ricky told me to call it.
Okay.
Off quick math that we were doing in our head, she stole a couple $1,000s worth of merchandise.
And you guys
told her to be concise because it'll help in, evaluating her future with us. And she asked, am I going to be fired for this? I need the job. And he was like, well, based off your honesty, and the more honest you are with us, we take that into consideration.
That's a crazy question.
Yeah, right?
Yeah,
You're stealing from me. So can I keep working here?
You guys have video and receipts for all these?
Yeah, we'll be able to provide that for you. Yeah, and from what she told us, she's been doing all the stealing for her family, for her sisters, her father, her mother. So like Rick said, he goes, it looks like your parents, your family put you in a predicament.
Yeah.
Well, that's what she said. She said she started a couple weeks ago, small stuff, and then she felt comfortable with it, and then it became every day that she was working.
Sounds a lot more like fraud.
Oh, she's going to text you.
I saw you walking in the store. I was gonna say maybe just hang out for a little bit. What's that? You guys already got all the information you needed from her?
Yeah, so I just haven't turned her yet. Did you? He kind of gave you a heads up. Just been with us for a month. A little over 1,000.
I made a copy of the receipt. I gave it to you.
That she was 18 years old. Ever had you guys want to do it?
He's kind of asking enough. Are you guys gonna prosecute her?
Yeah.
You guys gonna trespass her?
Trespass we don't typically do for associates unless she gets stupid, stands up and starts mother effing everybody, but I don't think she's going to. She's an absolute mess.
Is she?
All right, Samantha. So a couple things. All right. Certainly, anytime an associate causes a loss to us, right, there's some ramifications. So the team from Boynton Beach is here to talk to you. All right. So there's a couple things. All right. Here you go. All right. So because of this, we are going to prosecute. You understand that, right? Okay. But we still need our stuff back. Okay? Alright. One last thing, alright? This is a promissory note telling us that you're going to make it right with Coles. Alright? You still have your pen? Alright. Your principal amount owed is what you put on this statement. Okay? Alright, so you're going to write that there. You're okay, calm down. And then you're going to print your name and put the date. Did you get that water for you? So Samantha, I do have to make sure you just are aware whether or not you sign or not. It's okay, alright? You are being released from employment, okay?
Yes, sir.
You can't come back to Coles to work anymore.
Yes,
okay?
sir.
Alright. Alright, so these gentlemen are going to have some things that they're going to cover with you. Alright?
Yeah.
Alright.
Sorry, I signed a mistake there.
You're fine. Do you have anything in your locker that we should get for you while these gentlemen are covering a couple things for you?
It's just my bag.
Is it locked?
No, sir.
Okay. What's your locker number?
It's not the right one. It's the one at the very bottom.
What's the very bottom? I don't.
Like,
It's
it's
a
like
big
the-
locker room.
Is it in this, what locker number is the locker assigned to?
I was originally assigned to like 75,
It's
but
a white-
I
And the same row
don't
at the bottom?
I don't know
It's a white
if
bag.
no, it's
The,
yeah, it's a white bag.
Samantha, this is what I would say. Is this gentleman's going to ask you some questions. You be as honest and cooperative with them as you are with me. You understand? All right.
It's like when you enter in the door, it's like
Oh yeah.
He's gonna check,
this
he's
one,
gonna check. Don't
the
worry.
very bottom.
All right, Samantha. So I have to read you something before I talk to you, okay?
My Miranda rights.
Yes. Okay. So I'm required to warn you before you make any statement that you have the following constitutional rights. You have the right to remain silent and not answer any questions. Any statement you make must be freely and voluntarily given. You have the right to the presence and representation of a lawyer of your choice before you make any statement and during any questioning. If you cannot afford a lawyer, you are entitled to the presence and representation of a court-appointed lawyer before you make any statement during any questioning. If at any time during the interview you do not wish to answer, you are privileged to remain silent. I can make no threats or promises to induce you to make a statement. This must be of your own free will. Any statement can be and will be used against you in the court of law. Are you willing to talk to me without the presence of an attorney?
Under Florida Statute 817.034, scheme to defraud is defined as a systematic, ongoing course of conduct designed to obtain property through fraud or deception regardless of the dollar value of any single transaction. The statute targets the pattern, not the amount. The aggregation principle is what separates this case from ordinary shoplifting. 4 incidents of concealing a $40 cosmetic item, each a misdemeanor if charged individually under Florida Statute 812.015, become a single third-degree felony the moment a prosecutor demonstrates a continuing intent and a documented pattern of conduct. In this stop, loss prevention had documented 4 video-confirmed theft dates before the interview even began. That threshold was sufficient to support the scheme to defraud charge at booking. The additional days Samantha admitted to during the interview do not elevate the charge, but they eliminate any defense argument that the conduct was isolated, accidental, or a single lapse in judgment. The charging decision itself reflects sound legal judgment. Rather than stacking multiple petit theft counts, which would be defensible but tactically weaker, the officer correctly identified this as a scheme case. One felony count, supported by a documented pattern and a voluntary confession, is a structurally stronger prosecution than a series of misdemeanor charges that a defense attorney could argue are factually independent. The second major legal issue is the one with the most constitutional weight, the pre-Miranda confession. Before police arrived, Coles Loss Prevention conducted a full interview. Samantha admitted to stealing nearly every working day for approximately 2 weeks for herself, her mother, her sisters, and her father. That confession was made to a private employer, not a law enforcement officer. Under Illinois v. Perkins, 496 U.S. 292, 1990, Miranda protections apply only to custodial interrogations conducted by state actors, meaning law enforcement. A private employer's interview is not custodial interrogation under the Fifth Amendment, regardless of the pressure applied or the employment consequences implied. The practical application here is significant. Everything Samantha told loss prevention before the officer entered that room is admissible as evidence. The approximate dollar amount, the pattern of behavior, the family members she named as beneficiaries. None of that requires a Miranda waiver to come in. It was never subject to suppression in the first place. Loss prevention used the standard minimization technique during the interview, suggesting that honesty would be taken into consideration regarding her future with the company. Under Colorado v. Connolly, 479 U.S. 157, 1986, rendering a confession involuntary requires state coercion, meaning government pressure. An employer's implicit employment threat does not qualify. The confession remains voluntary and admissible. The third legal issue is custody timing, and this is where the officer's procedure either protects or exposes the case. Under Berkemer v. McCarty, 468 U.S. 420, 1984, custody attaches when a reasonable person would not feel free to terminate the encounter and leave. An 18-year-old, already questioned by her employer, sitting in a management office while police are called in, that person has no reasonable belief the door is open. The officer recognized the custody threshold. He read a complete Miranda warning before asking a single investigative question. The right to remain silent. The right to counsel. The right to a court-appointed attorney. Samantha acknowledged and waived those rights. That waiver is what makes her post-custody statements to police independently admissible on top of the LP confession already in the record. The result is a double evidentiary record, a pre-Miranda employer confession admissible as a private party statement, and a post-Miranda police statement admissible under a valid waiver. That combination substantially narrows the defense's available strategies before trial even begins.
Okay, so can you tell me what happened?
Oh god.
How about we do this? Let's give her a little breather. Alright, so she can regain her composure, and then we'll continue the interview afterwards.
Okay.
Sounds good, man?
Yes, sir. Sorry.
Just keep listening, Samantha. Everyone's going to treat you with respect. No one's going to yell at you. No one thinks anything. Okay? This was a mistake. But you need to stay calm for us, okay? Can we do that? Can we calm down for a little bit?
You want water?
Get the, go with the customer.
I'll punch her. Listen, we're going to take her through this door right here. So just grab the patrol vehicle and bring it around this way.
I don't think you're crazy.
Alright, so we're going to take out this door. Sorry, we're going to bring the car down. Okay, so I'm going to get a sworn statement from you because you were just interviewing her. So I'm going to have you raise your right hand.
What's the log of your right?
Yes, we interviewed this associate that works for us. She works in the Sephora department. We were actually doing an investigation on her today. Her name is Samantha Spear. Samantha's been with us since March the 14th of 2025. Through her employment with us, Samantha was found to be walking out of the store with merchandise that's not been paid for. Certainly was all found through video review, just following up on, daily habits with our associates in our departments. What we found is more than 4 occasions so far came in to interview. Certainly she admitted to many more events, all happening at the end of her shift, walking out of the store without any merchandise, never making a purchase. So she admitted to $1,000 worth of products.
Call at King Theodore. Is he advising that the friend is 97 and present?
And 1,000, is that the correct amount, or is that just what she admitted to?
That's what she admitted to. She's going to bring back all the rest of the product. Could be a difference. It could be a little bit more, but we won't know until it's fully back in.
10-4, I'm not sure how we can help him.
Alright. So that's it for you. I'm going to
They rented a lesbian rehab.
Well,
You're 10-4.
I have an officer statement as him, or should I get one from you
Before we
too?
go out there. to get
Yeah,
the
you can,
entry confirmation.
Alright, I'll just get one from you. So you could raise your right hand.
Okay, so basically Ricky and I were reviewing some audio, video, going over some testing exams that I'm preparing for. And an email came through, and during that email it read that there was possible dishonest association, dishonest associate activity with a particular individual. Upon review, Ricky and I had found on multiple occasions, on different days, her taking merchandise, concealing it either in her Sephora bag or her purse, and exiting the store.
Okay. And you guys wish to prosecute.
We wish to prosecute. It's a part of court policy.
Got to ask that too. So do you guys have like a list of the time she stole,
Yes, and that's going to be put into
including evidence.com?
detail
Okay, cool.
once he gets the information over for you.
All right.
Yeah, I'll drop a receipt in there for it. It's got the total of what we know until we can get back the rest.
Okay.
Like I said, based off, like I told you when we were walking back here, based off quick math that we did, it's $1,000. So in his, interviewing her, he said the more honest you are with us, the better it is for you
Yes.
during the whole process of it. So basically that was to jog her memory, to make it think harder, like, let me just put everything that I took. 'Cause you know what you took.
Yes.
For your mother, you took for your sisters, you took for your father, you took for yourself.
Okay.
And that'll give us an idea.
I need this one with 10 notes, and put me on with the only call that's in my zone by 975 Y. I'm back to black now.
Hey, Brian, 321 J10. Yeah, 32348.
So far, you're able to provide for us today the details on
I haven't reviewed video yet. Yeah, guys, you have video ready to look at?
Yeah, we have video.
So I could just check it out.
They need to establish whether we have scheme to defraud yet or not.
Okay.
So they've got 4 dates right now. Several $100s worth of stuff. 4 dates. They haven't gotten through all of the video yet. She's admitted to doing this for several more days.
1953.
For possibly 2 weeks. So, find out, get his opinion. This is part of the stuff you're going to have to do when you're on your own.
Yeah.
If we have the video for the 4th, we can scheme to defraud. The thing is that anything afterwards, at this point, would either be in addition to or a separate thing.
Okay.
So what we need to find out is what we have here today, what we can charge her with. If you guys are good after that, and you're just washing your hands clean from this because she's fired.
Will that be the report number?
Then
Yes.
that's a
Perfect.
But we'll get what we can get today.
Jeez.
Because that's
Yes.
probably the route that I would go.
And then I'll get all that file.
Okay. He's gonna bring his laptop. He's got everything in there.
All right.
We want to document it just so we can articulate everything we see. And then you guys will submit the videos later. We'll send you a link. You explain this to
He did, yeah, he got the information.
So then we can figure that up when we're submitting the whole packet to the state.
Correct.
Okay?
It's hers?
Yeah.
Okay.
I bet you thought it was mine.
Do you have your ID there so I could? It's up front.
No, it's fine.
Yeah, I don't carry it. Alright, so here she is last night. Let me pause it. So last night she comes up to clock out, carrying the same bag she's currently got in the office. Here you'll see she fidgets around, she's going to grab something off of here, and then she backs up.
And around what time is it?
9:04. She actually conceals the product at 9:06. So here she's looking at something. It's what she winds up taking, but she doesn't take it quite yet.
So
Coach
it
doesn't-
was that speaker that we...
Yeah. So she'll walk over here, walk back.
Now, as we're putting items in there?
No, not yet. She's already got a Sephora bag in her purse that she had already taken from inside the shop. But this is one of the first things that we saw her do. She'll go back out there on the aisle and she'll conceal a speaker that's out there. Alright, so here I'll back up just a little bit so you can see what she does. So she grabs, there's a Sephora bag back here. Okay. So you'll see, she grabs that bag. So you'll see there's already, I don't know if you saw it, there's already a couple things in there. She comes over here. Store's closed, by the way. It's 9:13 at night. We close at 9.
Okay.
She grabs here and here.
You good?
Yeah, I just thought about it.
What?
Having a female 1037 reader on the back.
Yeah, I'm gonna figure it out. Don't worry.
11:10.
Take 20.
I'll be right back, sir.
Anything else on
Take 20.
transporter?
Just turn your wrist down.
Take 1. Yeah, for the guy.
2-4 Delta. Uniform Juliet Papa. Report the
Take 100 North Federal. Outside 1.
Check some kind of outfit.
Come outside chasing.
Copy.
18 seconds.
Work has 2 shifts left, and I'm making her work. Just 2?
Yeah, we're Northeast 6th Avenue in Federal. Have a 640.
Hey, I hear they're hiring in Sephora.
Oh, man.
Oh, there he is. Get down, I was looking there.
Oh, they're trying to get the receipts.
She'll go and just start plugging stuff off, put it in the bag. Now we have controls in place that's supposed to prevent that shit from happening. It's like the 4th DA I've taken out of here with a store team to do a package checks like they should be.
How you guys catch wind of this?
Actually, the store associate gave us a tip that she was acting weird. So we started reviewing video of all of her closing shifts. And just boom.
Good for that person.
Started with this. We saw her conceal this last night. Now we're at this. Crazy. So,
You got everything we need?
you can have that, my friend. So I'll put. Is it okay if I put you
And you
in
haven't
our
even
internal report as the
okay.
officer?
It might
Perfect.
be even
And I have the report number. I'll send every video that I have. Do you want me to only send the video for this right now?
Yes.
Okay. Then what do you want me to do secondarily?
Well, the thing
If we
is
find
we're charging
more.
over scheme to defraud, so we've already seen that.
Yep.
Anything that we're doing, it's already like, it would just strengthen the case if you wanted to. It would be a supplement to the report, but it wouldn't be additional charges.
Yeah, fair enough. I don't
So what we're doing is
Whatever
what we
you
have
want.
right now, but
Okay.
because it's the systematic theft over and over again,
Okay.
it wouldn't be additional charges. That's what this all kind of encompasses.
Sure. Yeah. I want to give you whatever you want. So you just.
Because like, let's say that you come back later and it's a much higher amount or whatever it is, maybe there's an enhancement.
Sure.
I think there's an enhancement for the type of the amount that's being taken, right?
Yep, I don't think she's ever going to reach that. I think it's like $100 or something.
Oh,
I was gonna say, is it over like a crazy?
So
number
it
or
just
statute?
strengthens the case, but we already have quite a bit, and she's confessed.
Sure. No, I mean,
Right.
we get knocked over like huge shit. I mean, we still had like 400 cases last year, just straight shoplifting. So
And that's what you caught. So,
yeah,
Just keep calling us.
yeah, we will. Appreciate it, guys.
No problem.
Sorry for all the time.
no problem.
At the time of this analysis, Samantha Spear was charged with scheme to defraud, a third-degree felony under Florida Statute 817.034. If convicted, she faces up to 5 years in prison, 5 years of probation, and a $5,000 fine. All defendants are presumed innocent until proven guilty. The officer receives a B+. Miranda was administered correctly, completely, and at precisely the right moment after custody attached when loss prevention summoned police and before any investigative question was asked. The decision to charge under scheme to defraud, rather than stacking individual theft counts, reflects a solid grasp of how Florida's theft statutes interact and what a 4-date video record can support. The deduction comes from one procedural gap. The officer allowed loss prevention to present and solicit signature on a promissory note, a civil recovery instrument requiring Samantha to acknowledge a specific dollar amount while she was in custody and before Miranda had been administered. Blending civil and criminal proceedings in that sequence creates a suppression argument a defense attorney will raise. A clean separation between those two processes would have earned a higher grade. Samantha Spear receives a C. Her most consequential legal decision came before the officer entered the room, a complete. Voluntary confession to her employer with no legal obligation to say a word. The Fifth Amendment right against self-incrimination is not limited to police interrogations. It applies in any setting where a statement could foreseeably reach a criminal proceeding. Loss prevention is a private actor, but the information they gathered went directly into the officer's evidentiary record. She then waived Miranda and agreed to speak without an attorney. At 18, facing a felony on a first offense, invoking the right to counsel would have been the legally sound decision. Her cooperation throughout the encounter may be considered at sentencing or during plea negotiations, but it cannot undo the evidentiary record her own words created on both sides of the Miranda line. Cole's loss prevention receives an A-. The investigation was methodical and well documented. A coworker tip triggered a systematic video review. 4 dates were confirmed before the interview began. A sworn statement was provided to the officer on scene, and all surveillance footage was uploaded to evidence.com. This is the kind of organized, layered evidentiary package that makes a prosecutor's charging decision straightforward. The one mark against loss prevention is the promissory note. Asking an 18-year-old to write in and sign acknowledgement of a specific dollar amount while she is simultaneously in custody and facing a felony prosecution, and before Miranda has been administered, conflates a civil recovery process with a criminal investigation. Florida Statute 772.11 authorizes that civil demand, but it does not require it be executed in the same room at the same moment as an active felony arrest. Lesson 1. Employees are not required to speak to their employer about conduct that may be criminal. The Fifth Amendment does not distinguish between police interrogations and private employer interviews when the information gathered will foreseeably be handed to law enforcement. The right to say nothing applies in both contexts. Lesson 2. Scheme to defraud is not shoplifting. Florida Statute 817.034 aggregates repeated theft into a single felony regardless of per-incident value. 4 documented incidents of concealing a low-cost item is not 4 misdemeanors, it is 1 felony. And the pattern is the crime. Lesson 3. Miranda waiver is a legal decision with permanent consequences. Choosing to speak without counsel because cooperation appears to be the reasonable or honest course of action eliminates the only procedural protection remaining once the private employer confession has already been given. Lesson 4. Civil recovery and criminal prosecution are independent proceedings. Signing a promissory note that acknowledges a dollar amount to a retailer creates a written admission potentially usable in the accompanying criminal case. They should never be executed simultaneously or in the same room. Lesson 5. Admitting a pattern eliminates the accident defense. Samantha's acknowledgement that the theft occurred nearly every shift over approximately 2 weeks for multiple named family members removes any credible argument that the conduct was a single lapse in judgment. In a scheme to defraud case, the pattern is the offense, and she described it in detail. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. We read all of them. If there is a body cam interaction or legal question you want covered, let us know.
She was charged with scheme to defraud